Please. Excuse me. Excuse me. I'm gonna, supposed to do this side first. Not a weapon, sir. Pardon me, sir?
What are you doing in my car?
Sir, we're about to make a search of this car.
Why?
To do a search of this car.
Why?
Because,
You're looking to steal shit?
No, sir.
Well, what are you doing in there?
Sir, what is this?
What is what?
What is this here?
The fuck do I know? You got it, not me.
What's your name, sir?
This comes from out of your vehicle.
What are you doing in my car? I want to know.
I was doing a search, sir.
Why?
Because it was, I'm about to tow this vehicle, and,
You're gonna tow the vehicle? I'm here now. What are you towing it for?
I'm towing it because it was because the fire chief requested it to be towed. That's why I'm towing the vehicle, sir.
Okay.
What I want to know is what's this?
I'll be goddamn. What do you got there, son?
This is yours. This is the vehicle.
It's mine?
It was in your vehicle.
Who says it was in my vehicle?
I say it was in your vehicle.
I don't know anything about it.
Sir, can you get your hands out of your pocket?
Yeah, good.
Take them out of your pocket, sir.
I really have to?
Yes, you do, sir. I'm requesting that you take your hands out of your pocket.
I gotta think about it. What do you think? You think I should take my hands out of my pocket? You haven't done shit. So
Take your hands out of your pockets. Take them out and turn around, sir.
Why?
Because I said so. Get your hands away from your waist,
right?
sir.
I don't want to turn
Sir,
around.
take your hands away from your waist. Turn around, sir.
I don't want it.
I said turn around.
Fuck what you said, kid.
Sir,
I'm not going to turn around. All right?
Turn around.
No.
I'm not going to turn around.
Now, what are you doing with that gun, kid?
With what gun?
The gun you got in your left hand. What gun? You don't know you got a gun in your left hand?
This is yours.
It's mine. Got my name on it?
So it came from out of your vehicle.
How do I know you didn't put it there?
I didn't put it there.
How do I know that?
Just don't worry about what I know, sir. Just turn around
I'm
for
not
me.
going to turn around.
You're not going to turn
All right?
around.
I'm not going to turn around. All right? I think it's a bunch of bullshit. I think you're looking in my goddamn car to steal shit. That's what I think. See? That's what I think. Now what?
Beckett, can you take the cover position, the contact position? I have a weapon in my hand.
What the fuck? Are you being punished? Huh?
Am I being punished?
Yeah.
Sir.
Working with this guy?
Sir.
Huh?
I don't know.
Sir.
4 years now?
Sir.
Jesus,
Sir,
got
I
enough?
want you to keep your hands up.
I don't give a fuck.
Keep your hands up.
I don't want it.
I want you to keep.
I don't want to. What, are you going to shoot me now? Huh? Think
I
about it.
want
You
you
going
to
to shoot
keep
me?
your hands up.
I don't
Get
want
your
to keep
hands
my
up.
fucking hands up, all right?
Get your hands up.
shoulders, buddy. No. Now what? Now what? Grab him. What the fuck are you doing? Why don't you grab me? Huh? You're the badass. You grab me. Maybe you.
Sir,
Put your hands up on
get
your
your hands
I'm
up.
not putting my hands no fucking where. Now what?
Can't put
Huh?
your
What are you
hands
gonna? You're gonna shoot me now.
No, I'm not gonna shoot you, sir.
Well, what are you gonna do?
Cooperate. That's what I want you to do.
I don't want to cooperate.
Excuse
Now
me.
look at, look at. Were you here? You weren't here, right?
When?
I come out. These two cops are screwing around with my car. All right.
Okay.
There hasn't been a cop found guilty of crime until this morning's paper, right? That's fucking 10. This schmuck's searching my car to steal shit out of it, and now he's got this piece of shit gun. He don't even ask me if I got a license to carry.
Do you have a license to carry, sir?
None of your fucking business. Now what?
Sir. I'm gonna ask you for the last time.
Okay, this is, don't bother. No, I'm not gonna put my hands. I'm not gonna put my hands any fucking where. Am I under arrest?
Yes.
Oh, I am.
Yes, sir.
Oh, it looks like you're gonna have to take me, kid.
Yes, sir.
How we doing? How we doing? Didn't they teach you this shit?
Let that man go. He's in the...
Another backup. Get one cup on. It did. Hi there.
Call for another backup.
That's it, Bert.
anymore.
Bring that other arm. Bring that other arm back here.
101 to operation. Thumbs up.
Use two sets of
Send
cups.
us another backup unit down at the
Use two
rear
sets of
Private
cups.
Williams, sir.
You're all done struggling.
Okay.
Oh, sure.
Echo 2.
Okay? Yeah, I'm fine. How are you? Is it on? No. All right, let's get it. Let me get up. Let me get up and then we'll put it on. Oh, it is on.
Hey, boys. What do you do in my car? What? I'm fine. How are you?
I'm Officer Woodson. This is
Yeah?
Officer Parham.
How you doing,
Hi,
sir?
how are you?
The car was double parked over here. We were trying to find out which car started working. We're not trying to cause any problem or anything. But the
Okay,
car's double
good.
parked. We're legally parked.
Good.
So this your vehicle?
Yeah, it
You
is.
got some license and registration on it, sir?
It's in the glove. No, I don't.
You all have no license and registration?
No, I don't. I don't
What's
have
your
it.
name?
Beauregard. Beauregard, Farnsworth, Prefontaine. Anyway, I'm here now. You don't have to tow the car. Did you get a listing or anything?
What's your name again?
Prefontaine. Beauregard.
Let me spell your first name. You want to step back, sir?
B-E-A-U-R-E. No, I don't want
Okay,
it.
take-
B-E-A-R-U. B-E-A-U-R-E-G-A-R-D. Beauregard.
What's your last name?
French for good looking.
What's your last name?
Prefontaine. You know how to spell that?
You have a date of birth, sir?
Yes, I do. 7/15/41.
I'm sorry, who is this man in the way?
Who are you? Who are you?
I'm the person that's having your car towed.
Who are you?
Fire chief.
Oh, fire chief. You see any fires around here?
Your car was blocking the way of
Yeah,
one of my trucks.
I'm here now. It's going to be moved, all right? Why don't you
No,
run
it's
along
not.
and put out a fire someplace,
No,
all
sir,
right?
your car's being
Why don't you just run along and put out a fire someplace, all right?
We'll take care
I don't
of
need
it.
an
You
asshole
understand?
like you butting in.
Calm down, sir.
Understand his
Calm down,
car's
sir.
being
Who is this fucking jerk?
Calm
Huh?
down, okay?
Why don't you
Stand
take a
right
hike,
there,
little
please.
fireman?
Stand right there.
Go
Huh?
stand over there, okay? Go stand over there.
Why don't you go play with your rubber boots and your raincoat?
Go stand up there.
I'm in charge of you here.
Oh, you're not in charge of me, okay? Go stand up there, okay? Go stand up there.
Hey, look,
Can I take my goddamn car home?
Look, I just got over the radio.
This car's gonna be towed, okay?
My trucks are on their way down here now, and I want this car moved now. Huh? You can have it.
Okay, the car's gonna be towed. What do you want me to say? I told you the car
I want the car out of here now. My
Okay,
trucks
now
are
wait.
coming down. My
You see a truck
trucks
coming
aren't
down?
taking another route. Now I'm in charge of you here, and I'm in charge of the scene. I want this car out of here now.
back, sir. Excuse me, sir. You want to drive back?
You will move this vehicle now?
Some
Move it out of here.
You law against that?
Put your hands up, sir.
Is there a law against that, officer? Yes or
Do you
no?
have any weapons on you, sir?
I ain't saying nothing more. You tell me, is there a law against that?
No, it's not a law against having
Well, then what are you doing this
Why
to me
did you
for?
pull it out, sir?
He asked me what it was. I took it out and showed it to him.
Yes, I do. I don't want science there. Only officers over there. You're working on my authority. I want this car out of here. I got 4 trucks down here waiting to go back to another fire. They ain't got time to sell it.
Who are you doing in my car in the first place? You.
The car was double parked out here.
Yeah, but I understand all that. All right, all right. What were you doing in it?
Some identification type stuff.
Did you find any?
No, we did not find any.
Did you look in it?
Yes, sir. We
Did you look in the whole car?
looked where everything was in plain sight.
Okay. You didn't look anyplace else. I mean, I don't want to find nothing missing in there.
Look, this is ridiculous. Why don't you just give this man the okay to tow this car out of here? Can you say I got 4 trucks down there? Just stand by.
How can you be abused by this asshole?
You
He
have
works
the
for the
authority
city.
to move this car on my word, on my say-so. I want to move. Right there, tell him.
Yeah, Echo 102 is phone. 85, the rear, 85 wheels down, sir.
I don't have any. No. I drove it here.
You go over the car and drive.
That one. Is that against the law? Well, is it? I don't have it. I don't have any license. I don't know where it is. That's what I said. I don't know where it is.
Take the car. What are you doing around here, sir?
Visiting friends. Oh, I got a brother who works up at the academy. You know him? Harry Prefontaine. Hell of a nice guy, I'm told. You know him?
Is he here now, sir?
Oh, I don't know where he is. What?
Stand over there, sir.
I don't want to stand over there. I want to stand
Stand over there.
right here. God damn it. You got enough cops here?
Yes,
4 of them.
Where's your license?
I don't know where it is, I told you.
Mike.
You have
Mike.
one?
Yeah, I got a license.
Doesn't have a license on him.
He's going down. Let me get some information.
It's on the website.
You get in the car? Sir, do you have a license for this weapon?
What weapon?
The weapon that was in your car.
Oh, don't give me that shit, kid. Don't give me that shit. What weapon in my car?
Put your hands to your side. Put your hands to your side, all the way out.
With my...
Put your hands to your
Wait.
side.
What, are you going to shoot me now?
No. Put your hands to your side. Unless you have a license for the weapon, you're coming inside, so we'll take it on.
Am I under arrest?
You have a threat. Answer the man's question, sir.
I'm going to answer my question. Am I under arrest? Oh, I'm not under arrest.
Do you have a license for that weapon, sir?
I don't have any weapon.
There's a weapon in the car.
Was that Kyle Lockwood you got here?
Put your hands by your side.
Was that
turn
car,
around.
look, was that car locked when you got here?
No, it wasn't.
Okay.
You left the keys in the ignition. Turn around, sir. Put your hands by your side all the way out.
No, I don't think I will.
Put them all the way out.
I don't think I will. I don't have a weapon. I don't have any weapon. It's your vehicle. It's my vehicle. Okay. So we'll fight on your way. Take me? You gonna take me? Why don't you take me? Why don't you take me, Moose? Huh? Why don't you take me? Jump my head, boy. I paid $26. I want him to take me. How you doing, guys? Huh? You taking slow, right? You taking bad? You gonna take me? Can I get this goddamn vehicle out of here now?
Fucking cuffs over here, restaurant. Give him another set of cuffs, because my arm. Give him another set. 2 cuffs. Can I go?
I got to get him out.
No? Taking up on fire?
Keep your hands on.
Okay. Everything's going easy.
You two take him to the car.
Okay.
You got him?
Up easy, sir. Up easy. We'll take him
Okay.
up to the car. What's this, sir?
Take them back to the car.
What are these?
Nothing.
Nothing. Okay.
Officer, let me throw in the car or what?
What's this?
You have any more weapons on you, sir?
I ain't saying nothing. I want a lawyer.
You have anything, any needles that might stick me?
I got nothing to say to you, kid.
Get a kick out of doing this, the white boys, do you? Huh? Down in Georgia, we don't know what to do with you guys.
What's this, sir?
The trial court of the Commonwealth of Massachusetts is now open for session. The Honorable Judge Arthur McCarthy presiding. Come forward and your case shall be heard.
Please, make a motion to dismiss. Make a motion to dismiss. For one of prosecution, we're here.
I'll take that under advisement. Sit down.
You're juggling this. I'm here for I need a defendant. My client and I are ready for trial, Your Honor.
Counsel, please sit down. The motion in contempt of court. Is the Commonwealth ready? Ready to vote, sir?
I'd like to renew my motion, Your Honor.
Be seated, Councilor.
Where's the jury? Is this jury waived?
You have chairs? Jury, you have chairs? 6 chairs, on the top.
Ready? Commonwealth ready? Commonwealth ready, Your Honor. Defense, Counsel Flag.
Yes, Your Honor.
On the record, Your Honor, Assistant District Attorney William J. Walsh for the Commonwealth. Good morning, Your Honor. Good morning. My brother will identify himself for the record.
Elmwood P. Suggins, Your Honor.
This is the case against Commonwealth versus Beauregard Prefontaine. We, the Commonwealth, will call Officer Woodson to the stand.
If Your Honor, please, may we know the charges?
Someone should read them. There should be a clerk to read them. Clerk, you have the charges?
Yeah.
Swear the officer.
First case is Commonwealth versus Prefontaine. The charges are dangerous weapon carried to wit, a handgun, assault and battery on a police officer, leaving a firearm unattended in an automobile, and disorderly person.
Okay, we'll call Officer Woodson to the stand. Swear him in.
Remain standing. Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
Sit, please.
Good morning, Officer.
Good morning.
Could you please state your name for his honor and for the record, please?
Officer Michael Woodson, sir.
Where are you assigned, sir?
Area 85.
Who were you employed by?
Boston Police Department, sir.
Okay, were you in the capacity of your duty on the 20th of February at approximately 9:55 a.m.?
Yes, sir.
Okay, did you have occasion, sir, to be directed to the area of 85 Williams Avenue in Hyde Park?
That's correct, sir.
When you were there, what did you see when you first got there, sir?
I arrived and met with the Fire Chief O'Malley, who ordered us to tow.
I object, Your Honor. What did he see?
What did you see, double parked. They're blocking some fire trucks.
Okay, officer, did you have occasion to have a conversation with anybody at that time?
Not at the fire chief.
Okay, what did the fire chief say to you, sir?
I object. Hearsay, Your Honor.
It's not hearsay, Your Honor. Statement, the conversation was with this officer.
If Your Honor, please, the fire chief is in court, he can speak for himself.
Objection sustained. Okay, what did you do as a result of your conversation with the fire chief, officer?
We went to back to the cruiser to radio in for information on this car, requested a tow truck.
Okay, did the tow truck come?
Yes, sir.
What did you do before the tow truck came, officer?
Did an inventory search.
Okay, what did you search?
We searched in the area, the lunging area of the motor vehicle.
All right, what area did you search? Can you be
We searched
specific?
under the seat, the glove compartment, the back seat, also in the back rear of the station wagon.
Okay, and did your inventory search reveal anything, officer?
Yes, sir.
What did it reveal?
A .22 caliber weapon found in the glove box, sir.
Okay, and what else? Anything else?
No, sir.
Okay, do you have that weapon with you here in court?
Sir, yes.
Okay. What did you do after the inventory search?
I told my partner we had a weapon, at which time the owner approached us on the scene.
And how did you know that was the owner, officer?
He stated that he asked us, should I tell exactly what he said to him?
How did you know, officer?
He said, what the fuck are you doing with my automobile?
Okay, and what did you reply to him?
My partner and I approached him, and my partner officer taught him, told him exactly what was going on.
Okay, and what happened then?
Such time he was very erratic and wanted us to get away from his motor vehicle, and the tow truck arrived. The fire chief told him, I want the motor vehicle towed.
I object, Your Honor. The fire chief is here.
Rephrase your answer, please. Sir, can you repeat the question?
Okay, was any orders issued to this person who approached the vehicle?
Yes, we told him to stay.
I object, Your Honor. Was there any orders? Yes or no? Period.
Yes, sir.
Okay, and as a result of the orders, what were the orders?
We told him to stay right there. We asked him for identification. We also asked him, did he have a proper license to carry the weapon in the automobile?
Okay, he was shown the weapon.
Yes, the weapon.
Did he acknowledge ownership of the weapon?
Yes, he did, sir.
Okay, and what did he say when you asked him about having a firearm? License.
He told me he didn't have one, sir.
Okay.
He also stated that he did not have any identification on him at this time.
All right, and what did you do after that conversation, officer?
At which time we called for backup. The Echo 102 responded, officers Mendez and Renwick, sir.
Okay, and what happened then when the backup showed up, officer, if anything?
At which time the suspect was then placed under arrest, sir. Before being placed under arrest, we had a minor...
Your Honor, please, what happened then? He was placed under arrest before. Let him answer the question, please.
We had a scuffle.
A scuffle?
Yes, sir.
Describe the nature of the scuffle, officer?
Yes, sir.
What did it
Well, prior to the scuffle, sir, though, we...
I object. What did it entail? He's got to be responsive, Your Honor.
Listen to the questions and answer the questions.
Can you repeat the question, sir?
Yes, what did the scuffle entail, officer?
Well, it entailed 4 officers trying to put handcuffs on him in order to place him under arrest. He resisted arrest, kicking, shoving, and et cetera, et cetera.
Who did he kick specifically and shove, officer?
Well, I was kicked in my left shin.
How many times?
Sir, I believe once.
Okay.
And it took two pairs of handcuffs to subdue the suspect.
Okay. Were there any other officers struck during the course of this scuffle?
Well, the contact between Officer Mendez and Officers Renwick.
Do you know where they were struck?
No, sir.
Okay. What did you do after the suspect kicked you?
I backed away. The suspect was put under control by the rest of the other 3 officers.
Okay, did you have to require any medical attention for the
No, sir.
contact that was failed there? Did you, okay, what did you do after the suspect was arrested, officer?
Sir, then we called for a wagon. The Echo 202 responded, And
I object. What did you do afterwards?
Well, he answered the question, Your Honor.
And he continued. This is not some tone for him. He must respond to the questions asked, Your Honor.
Just respond to the specific question.
we called for a wagon to transport him.
Okay, and what happened next?
Wagon arrived, and he was transported to Area 8, sir.
Okay, was the defendant entitled to his rights, officer?
I believe so, sir.
Not by you, though. Okay, what was the defendant charged with, officer?
Being charged with unlawfully carrying a weapon, assault and battery on a police officer, disorderly person, and also, if I may refer to my notes,
Go ahead.
leaving the firearm unattended in the motor vehicle.
Okay, there's a couple of other questions before I go. Were there any other people present during the course of this incident with the suspect?
Yes, sir, the tow truck driver, as well as the other two officers.
Anybody else?
Well, a crowd did gather, sir.
How many people were in the crowd?
I would say about 15 to 20, sir.
15 to 20. Okay, and you said
And also the fire chief, sir.
the defendant was charged with assault and battery on a police officer. How many counts of that, sir?
I would say 4, sir.
For the 4 officers?
That's correct, sir.
All right. Did you ever at any time see the defendant inside the motor vehicle with the gun was
No,
found?
sir. No, sir.
Okay. Do you see the person you placed under arrest known to you as Beauregard Prefontaine here present in court today? Record reflect identification of the defendant, Your Honor.
Court is not.
Thank you. No further questions this time, officer. Cross-examination, officer.
Please be seated, officer. I'd like the officer to be able to refer to this notice if necessary. Please, Your Honor. This will only take an hour. You testified in direct, my worthy brother here, that I talk a lot to my own self, that this all occurred on the 20th. Is that true?
Yes, sir.
Occurred on the 20th. Okay? Would you please take out your 1-1 report, officer?
Yes, sir.
On page 1, what is the date of occurrence?
0221, sir.
Say that again?
February 21, 90, sir.
So it occurred on the 21st?
That's correct, sir.
Did you testify that it was the 20th?
Yes, sir.
You did, okay? Little mistake.
Yes, sir.
You know what day it is today, son?
Yes, I did, sir.
What's today?
Today's Friday, sir. Friday the 21st.
On your form 2-1, sir, your booking sheet?
Yes, sir.
What's the date on that?
#21st, sir.
21st? Is that what it says?
The date of the report or
In
date?
block 06, does it say 22 there?
Sir, I have 21.
You have 21? You don't have a 2 in block 06?
Sir, I have a 2 scratched out with 1, sir.
Oh, I see. Would you spell Prefontaine as on that booking sheet, please?
Prefontaine, sir.
Okay, and Beauregard?
BUR8GOD, sir.
Okay. Back to your 1-1. Spell Prefontaine.
I object, Your Honor. If any spelling mistakes are made in the 1-1 booking sheet, they're mistakes as to form and not substance. And this line of questioning is totally irrelevant to the charges.
May I be heard, Your Honor?
Go ahead, Counselor.
Thank you so much. I am going to point out so many errors made by this officer that it's going to show you his credibility is 0, Judge. He can't spell the name, he can't spell different words in it, he doesn't know what date, he testified already for the wrong date. This officer's credibility is at stake. Not whether or not he knows how to spell. He signs a document that spells my defendant's name one way, and then he signs another document spelling it another way.
I'll take that under advisement, Counselor.
Okay, officer, you testified you did an inventory search of the vehicle. Is that true?
That's correct, sir.
And you searched the lunging area. Isn't that what you said?
Yes, sir.
Is that what you searched when you do an inventory search? The lunging area?
No, sir.
So that's a lie. Isn't it a lie?
Yes, sir.
Yes, sir. I'm sorry. You searched the whole car, didn't you?
Yes, well, not the whole car, but the front seat, sir.
You're supposed to search the whole car, aren't you?
That's correct, sir.
But you failed in your duties, didn't you?
That's correct, sir.
Did you find a gun in a glove box?
Yes, we did, sir.
Did you find a gun in the glove box?
Yes, sir.
You lying, ain't you?
Objection.
When Beauregard 3 foot... No, I won't. No, I won't, Your Honor.
Yes, you will, Counselor.
No, I won't, Judge. When my client arrived, you never found a gun in that car, did you?
Yes, I did, sir.
You never found a gun, did you?
Objection asked and answered.
The officer, did you find the gun? Yes, sir. The answer is yes.
You did an inventory search of that vehicle yourself.
Sir, not myself, sir. I'm caught him and myself.
Okay, and you found the glove in the glove box. That's what you're saying. You personally went into the glove box and took the gun out. Is that true?
I did not take it out, sir, but I discovered the weapon in the glove box.
You found it there?
That's correct, sir.
Was that before or after Officer Mendez arrived?
That was before Officer Mendez arrived, sir.
And you say here under oath, did you ask my client whether or not he had a license to carry a firearm?
Yes, sir.
And he said that he did not?
That's correct, actually, Fred.
Didn't he say he wanted a lawyer?
No, he did not, sir.
He said he did not, huh?
That's correct, sir.
You better don't have these kids expressed that I would have caught them in little pieces. Let me ask you something else. Did you ever see my client with a gun?
No, sir.
It is your testimony here, under oath. Think carefully. Think carefully, officer. You testify here under oath that my client acknowledged ownership of that weapon, yes or no?
Sir, to what? Yes.
He said to you, that's his gun.
Sir, that when the question was put forth to him, he said, it's none of your business.
Oh, so then he didn't claim knowledge of ownership of that gun, did he? Did he?
Not correct.
That's twice, Judge. That's 2 perjuries. You say it for a crowd gathered.
Yes.
Wasn't there a crowd there when you got there?
Yes. Yes, sir.
By the way, who made up these lists of so-called charges against my defendant?
Myself and my partner, sir.
Who made up the list? You can't both write on the thing at the same time.
I actually wrote the report.
You wrote it. What do you know about leaving a firearm in a car? Under Chapter 140, Section 131C. What are the elements there? Do you remember?
Sir, I can give you some, sir.
Suppose I read them to you, officer.
Thank you.
No person duly licensed shall carry a firearm unless it's under his control in a motor vehicle. Then you're saying my client is lying? Is licensed?
Sir, I don't see your point, sir.
My point is you have to be duly licensed in order to be violating that statute.
That's correct, sir.
So he's licensed.
No, he's not, sir.
Well, then why did you charge him that crime?
Sir, I cannot answer that question.
Nash, you say my client kicked you?
Sir, yes.
What did he have in his feet?
He had boots, sir.
He had boots. Let me think about that. Now, if someone kicked you, what's the appropriate charge?
Assault battery, sir.
Assault and battery.
With a boot.
Shut up.
With a shoe, sir.
Assault and battery what?
To whip a shoe.
To wear a shoe?
Short foot, sir.
It wouldn't be assault and battery by means of a dangerous weapon, would it?
No, sir.
It would not. To wear a short foot?
Yes, sir.
It would be. 265, 15A.
That's correct.
But what did you charge him with?
Carrying a weapon, sir.
What else did you charge him with?
Assault and battery on a police officer, sir.
265, 13D, so that's wrong too. Does it say 4 counts on there?
Not on the report, sir.
No, nowhere does it. Where in your report does it say about the crowd gathering?
Sir, it does not.
It doesn't, does it?
No, sir.
It doesn't say anywhere in there about a crowd gathering. That disorderly person stuff, that's all fictitious, isn't it?
No, sir.
It's not. Officer, I'm going to put a citizen who watched this whole thing through the window. The whole thing through the window. And he won't lie either. He'll tell nothing but what he saw. Let me ask you that. Give me that, please. Give me that one more. Did you comprise this tome here?
Yes.
Is this your product of your work? Is it?
Combination, sir.
Combination, huh? Who signed it?
I did, sir.
Officers noticed a WIP. What's a WIP?
Sir, intended to be whipped, sir.
Okay, fine. Let's see. Suspect was placed under arrest. If I may, Your Honor. Backup was requested. Officers Renman and Mendez responded in the Echo 102D. On arrival, the suspect was placed under arrest. A search of the suspect, incidental to a lawful arrest. Nowhere, Your Honor, nowhere, ladies and gentlemen of the jury, nowhere does it say one word about anyone being struck. Nowhere does it say anything about a crowd being gathered. Nowhere. Let's continue along. Suspect was then read his rights. Transport hearing by officers. However, there's something here to which you never alluded. A search of the suspect incidental to a lawful arrest resulted in the discovery of weapon number 2. Is that true?
That's right, sir.
Described above in his right boot.
That's right.
Did you take a weapon from his right boot?
Officer Mendez did, sir.
Did you take a weapon from his right boot?
No, I did not, sir.
Mendez is going to get on the stand and Mendez is going to get on the stand and he's going to testify that he took a weapon from my client's right boot.
Sir, if I can recall the scene, sir.
I asked you a question, son. You testified, you submitted this 1-1 report, did you not?
That's correct, sir.
You testified under oath that Mendez took a gun from my client's right boot, did you not? You want to change that?
Yes, I do, sir.
What do you want to say now?
Sir, I believe either the weapon either fell to the ground out of his boot during the scuffle, sir.
Did you see it fall to the ground out of his boot? Yes or no, officer? If you can distinguish.
No, sir.
You did not.
However, I believe...
I know what you believe, son. What you saw, heard, like that. So then you admit that assault and battery on a police officer is inappropriate, don't you?
Excuse me, sir?
The assault and battery complaint on a police officer, that's inappropriate, right?
No, sir.
Oh, it's not. What exactly do you want to convict this kid of?
Sir, the weapons charge, sir.
Weapon?
Assault and battery on a police officer.
Unlawful what? Let me continue along. Where he was put for unlawful possession of a firearm. Is that what you're charging with? Yes or no, son?
It's meant to be unlawfully carried, sir.
Unlawfully, another error in the report. If you look on this and it said, dangerous weapon carry 2-weight handgun, 26910, subparagraph B. What if I told you, son, that under subparagraph B, that's unlawful carrying 17 dangerous weapons, none of which is a firearm? Another small mistake?
Yes, sir.
One other thing. Now you admit my client never said he owned the gun. Is that true? Yes or no, son?
Not in those exact words, sir.
Did he, yes or no? Did he say that's my weapon?
No, sir.
Did you see him move the weapon in any way, shape, or form?
Which weapon, sir?
The weapon, let's talk about the first one that you didn't find in the glove box.
Sir, I did find it.
Not the one you didn't find in his boot. The one you didn't find in the glove box.
Sir, I did find it.
You did find it in the glove box. Okay. Was the car open or locked?
It was unlocked, sir.
It was unlocked. The windows open or closed?
Partly, sir.
Partly locked.
Open.
Partly open. Was the glove box locked or unlocked?
It was unlocked, sir.
Did you see my client put that gun in the glove box?
No, I did not, sir.
Did you see anybody put the glove in?
No, I did not, sir.
You don't know who put it in there, do you?
That's correct, sir.
You do not know who put it in the glove box, yes or no?
No, sir.
Thank you.
Tell us about that, stand, Rob.
Good job, Mike.
See,
Yeah, he's sworn.
no, he's sworn. They're all sworn. Good morning, officer.
Good morning.
Just state your name for your honor for the record, please.
Officer Frederick Mendes.
Okay, and what do you do for a living, sir?
I'm a police officer.
Where do you reside?
Area 85.
Okay, did you have occasion to be on your duties on the 21st of February, 1990, at approximately 9:55 a.m.?
Yes, sir.
Did you have occasion to be directed to 85 Williams Avenue, Hyde Park?
Yes, sir.
Okay, were you working alone or with a partner?
I was working with Officer Renrick, sir.
Okay, were you in uniform or plainclothes?
Uniform, sir.
Did you have occasion when you were there to encounter a motor vehicle?
Yes, sir.
And was anything found in the motor vehicle?
Yes, sir.
Did you know what was found in the motor vehicle?
A .22 caliber
I
rifle.
object, Your Honor. Do you know?
Yes, sir.
What was that, sir?
A .22 caliber revolver, sir.
Did you know where that was found?
Yes, sir.
Where was that, sir?
In the glove compartment.
Okay, do you have that revolver with you here, President?
Yes, I do, sir.
We'll stipulate to the ballistics report.
Okay, thank you. Now, one gun was found out. So you aware of any other weapons which were found in the area?
Yes, sir.
And where were they found?
One was found on the scene itself, sir.
On the scene, okay. And the second one, sir?
On the scene, that's the one I'm referring to.
But where specifically at the scene, officer?
By Beauregard Prefontaine.
By him or on him, officer? Where was the gun?
It was by him. It was on the ground.
Okay. Where was it on the ground next to him?
Next to...
I object, Your Honor. Where was it on the ground next to him? He's leading his own witness.
I withdraw the question, Your Honor. Where was it, sir? Exactly.
That was found by his feet, sir.
By his feet. How far from his feet was it?
About a foot and a half.
Okay. Did you retrieve that weapon?
No, I did not, sir.
Who retrieved that weapon?
Officer Mike Woodson.
If you have that weapon with you here, President?
Yes, I do, sir.
It's inevitable.
Months ago. Simone had to be the banker, but there's no way to make him. Now, I want him to think he's holding paper on a cop, make an approach to get the stuff back.
Don't you as Beauregard Prefontaine?
Yes, I do.
Your President Court today. Could you please
Yes.
point him out and identify him for the record?
Gentlemen.
Okay, officer, during the course of the arrest of Beauregard Prefontaine, were you, what happened?
Officer Renrick and myself arrived on scene as a backup unit to assist Officer Mike Woodson and Officer
I
Parker.
object, Your Honor. I don't need his life story. What happened in the arrest was the question.
Okay, when I arrived on scene, I was directed by Officer Woodson that there was a gun in the glove compartment of the automobile.
Specifically regarding the arrest of the defendant. So
Thank
after
you.
when the defendant was arrested, did anything happen, to the best of your knowledge? In the course of the arrest?
Okay. A weapon was found on the, next to Beauregard.
Testify to that. Anything else happened, officer, in the course of the arrest?
A scuffle ensued.
Describe what happened.
We tried to perform a frisk of Beauregard Prefontaine, and he resisted. So we were using a minimum amount of force to control him to continue the search, the frisk of the Mr. Prefontaine.
Now, was this before or after the gun was found on the
The
ground?
gun was found after we, well, during the frisk itself.
Okay. And you said a scuffle ensued.
That's what took place. He didn't want to be frisked.
Could
It
you
took four of us.
describe in detail what happened in the scuffle, please?
Okay, we approached him to perform the frisk. He asked us if he was under arrest. We said no, he was still resisting at that point. So it took four of us to control him to perform the frisk. Officer Woodson found the weapon on the ground next to him, and we arrested him at that time.
Is that all that happened, officer?
I believe so.
Was any other officers, to the best of your knowledge, assaulted by the defendant?
I object, Your Honor. He's leading the witness again.
Objection sustained.
Request that be stricken from the record. The memory banks of these 6 jurors, please.
That's already been established.
Thank you so much.
Thank you, officer. No further questions. No witness.
Very briefly. At the time you arrived, did Officer Woodson found the gun, if you know?
Which gun are you
The gun, the gun that was in the car in the glove book?
Yes, that's my knowledge.
Yeah. And my client had already claimed ownership of the car, is that true?
Ownership of the car, sir?
Yes.
Yes, sir.
You never heard him say that was his gun in the car, did you?
No, I did not.
Why were you frisking him?
I was frisking him for, the suspect had a bullwhip on him. He claimed ownership of the car, which was, gun was found in the car. For my safety, as well as the safety of my fellow officers, I wanted to see if he had weapons plus one.
You were afraid?
Yes, I was.
Did you see the whip on my client?
Yes, I did.
You did?
Yes, I did.
Think about it. Wasn't it on the deck already when you got there? Think about
You're absolutely correct.
it. Yes. So you never saw a whip on my client, did you?
No, I did not.
So what are you screwing with him for? Why is he under arrest? You say he's not under arrest. Is that what you're saying? You're saying my client at the time you approached him was not under arrest?
Objection as to the following question.
Okay. Let me rephrase. Forgive me, Your Honor. To the best of your memory, officer, when you, Renwick, and Parham, and this liar here, all approached my client, you already knew there was a gun in the car. Is that true, yes or no?
Yes.
Did you know Woodson was going to charge my client with unlawfully carrying a dangerous weapon?
No, I did not.
Objection, Your Honor, to the question. Cause for conclusion, not the officer.
Sustained.
Your Honor, please, he's a police officer. He should know whether or not there is a charge here for unlawfully carrying. He's been well trained.
Your Honor, the following question requires the witness to go into the state of mind of another individual. He's not capable of answering.
Particularly if he doesn't have a state of mind. So you were going to frisk my client, is that true?
Yes, I was.
Okay. At no time did you see a gun in my client's boot. Proof?
This is correct.
Did you hear him testify that he took a gun from his boot?
Yes, I did.
He was lying, wasn't he?
Oh, I thought it was a rhetorical question.
No, I don't ask rhetorical questions, son.
I couldn't state to the fact that he was lying or not.
So he's not under arrest at the time you approached him, right? He wasn't under arrest.
No, he was not.
So he objected to you before he was putting your hands on him, didn't he? As a matter of fact, at that time, you threw him down over the hood of a blue truck, didn't you?
No, I did not.
Was his head bounced off a truck? You want to see the emblem, kid? Was his head bounced off a truck, yes or no?
I approached him.
Was his head bounced off the truck, if you know?
To the best of my knowledge, no, sir.
The four of you handcuffed him, didn't you?
That's correct.
For what?
To conduct a frisk.
You hit 4 policemen handcuffed my client to conduct a frisk?
Objection, Your Honor. Asked and answered.
Sustained.
Did you handcuff somebody to frisk them?
We are allowed to use the minimal amount of force to conduct a frisk.
Your Honor, please. I asked a specific question, to which I request a specific answer.
Respond to the question, officer.
Can you handcuff somebody to frisk them?
Yes.
Let me ask you this, officer. In the course of your training, were you taught that if a passerby went by and saw 4 cops on top of my client, handcuffing him, he would be under arrest, whether or not you intended to arrest him or not, yes or no?
Depends on the circumstances, sir.
4 policemen had my client across the hood of a car and were putting handcuffs on him. 4 policemen. Okay? Weren't you taught in constitutional law that that would be an arrest? Yes or no?
Yes.
Thank you. So he was under arrest then?
No, he was not.
He wasn't under arrest. I have nothing further, Judge. I made the point I need to make.
That, Your Honor, is the Commonwealth's case.
Oh, good. Be seated. Okay, Your Honor, please. I need a motion to direct the bill to my request. Required finding I'm not guilty relative to 140, 131C. I mean, they just can't have it. It's not one of the elements. Okay? I also request not guilty on A and B and a PO, and there's been no real evidence towards that. Also on the disorderly charge, Judge. Now may I be heard? Go ahead.
Your Honor, at this point in time, the Commonwealth's burden is not to meet the evidence beyond a reasonable doubt. The Commonwealth's burden is to meet the evidence by a
Favor of the prosecution and
In the 140, 131C?
no, we'll dismiss that. The 141 is 140, 141C is dismissed.
So you're going to go on with assault and battery on police officer?
Yes, no.
The disorderly person?
Yes, sir.
And one count of unlawfully carrying?
Unlawful carrying dangerous weapon.
Sorry, complaint on witness.
Which one? Your Honor, please. It should be thrown off of vagueness. It doesn't say. Which one?
And on the
But in any case, Your Honor, let me see this in fact. These officers have been trained at the academy, hopefully, that in order to find someone guilty of unlawfully carrying a dangerous weapon implies a movement. There have been Supreme Court decisions that say that must be moved. Commonwealth versus Jones, to be exact. Further, simply being in the car with a weapon is insufficient to find my client guilty, even if he did move the car. There must be some testimony to his acknowledgement of having ownership of the weapon. There is no such testimony except when he lied and then retracted. There was no such testimony. You don't know who found the weapon. You don't know where the weapon came from. We respectfully request that he be found not guilty and on charge on this. This is outrageous, an egregious miscarriage of justice.
This is closing argument, then I take it, right?
Yeah.
Your Honor, ladies and gentlemen of the jury, the defendant, Mr. Prefontaine, has this morning been charged with dangerous weapon carried with a handgun. The Commonwealth would allege that the defendant should be found guilty of that beyond reasonable doubt. Now, our burden at this juncture is high. It's beyond a reasonable doubt, but it's not beyond all doubt. And the jury may find, as to count one, that the defendant has carried that weapon, in fact, because he had possessed it, the car had been moved on a public way, and the fact that 85 William Avenue is in fact a public way. Now, the possession doesn't require the defendant to be on the person of the defendant. It can be constructive possession, which is the ability of the defendant to exercise dominion or control of the gun. And the Commonwealth's theory in this case would be that the defendant was in fact in constructive possession of at least the gun which was found at his feet during the course of the officer's inquiry, relative to count one. Please, we've heard evidence from the officer.
Your Honor, please, there's only one count here. He's on a different one.
The first officer that took the stand was Officer Woodson. Officer Woodson did in fact testify under oath that he was kicked by the police officer. It's an assault and battery on a police officer. Could it be a lesser included offense of an assault and battery by means of dangerous weapon? Yes, it could be in this circumstance. And that's what the officer chose. Shot the defendant with, and he should be found guilty beyond a reasonable doubt of assault and battery on a police officer. Due to the fact the officer was kicked by the defendant. And ladies and gentlemen of the jury, we have testimony from the officer on the oath again this morning that the defendant was in fact a disorderly person. That people were at the scene, about 15 to 20. Ladies and gentlemen, when the crowd was there before the incident happened, or the crowd was there during the course of the incident, the defendant was still a disorderly person to the crowd. Is it a reasonable inference that his actions, the actions of Mr. Prefontaine, annoyed or caused some sort of antisocial behavior to the crowd? Could that be an inference which reasonable men and women could draw from the defendant's conduct after seeing this incident, I would submit to you, ladies and gentlemen of the jury, it is. And the defendant should be found guilty on counts 1, 2, and 4. Thank you.
The jury has got one in.
Excuse me, Your Honor. Relative to your charge? You're going to speak to him relative to the charges, and certainly I respectfully request in your charge to explain to him that the final statement of neither myself nor my murdered brother here is evident. And in fact, the definition that this learned attorney here has given of disorderly person isn't even close, and I'm sure Your Honor will correct that. Annoyance to people, make them antisocial behavior, that's outrageous, Judge. Absolutely outrageous. He also spoke to 2 charges of 2 guns. We got 1 charge here. I respectfully submit that the court needs to explain to these people which gun charge, if any, is being brought against my client. Thank you.
Jury, before you make your decision, the dismissal of leaving the firearm unattended motor vehicle is dismissed because of the Commonwealth's failure to prove, according to the testimony of officers, on the dangerous weapon carrying unlawfully. That will be dismissed, and you're to make a judgment on disorderly and assault and battery of a police officer.
We'd like to make complaints for perjury against Officer, whatever his name is there. Woodbury, Wood.
You have 30 seconds, jury.
Your Honor, I forgot my witness who was watching out the window.
I'm sorry, counsel.
I know it, but it would have been great. I'm sorry, Sergeant O'Hare.
I still get the money?
Yeah, you still get the witness fee.
Not guilty on all charges.
Here you go, kid. See you later.
Just a brief thing on what happened here. Number 1, definitely count 3 was you shouldn't have been charged with count 3 because it requires that a person have a license, right? And the license firearm carrier wasn't done unattended motor vehicle. Clearly the wrong charge, count 3. Relative to count 1, it wasn't carrying because carrying the other 3 elements. Possession of the gun, it can be constructive, but possession plus movement, some movement, even slight, on a public way. You couldn't prove possession here. The guy was outside the car. And on the second count of carrying, the gun was at his feet, a foot and a half away. Very shaky case. Should have been maybe possession of a firearm.
Public place.
Public
Place.
Yeah, wait, or public place, whatever. All right. And number 4 was assault battery on a police officer. If you got 4 assault and batteries on a police officer, you got to make four charges. Every single assault and battery on a police officer or ABDW is a different count. So if you only put 1, but 4 officers have punched or kicked or whatever, of course, there's got to be 4. There should have been 1, 2, 3, 4 of them here, not 1. We can only prove 1. We can only prove what the complaint says. And relative to disorderly person, that was again clearly borderline. Remember, you have to prove that someone's disorderly, not to you as a police officer, but to somebody else, a member of the public, even one other person. That's what you need. Public inconvenience, annoyance, alarm, something to that effect. No legitimate purpose for being there. So it wasn't the strongest case. And you see what sloppy paperwork can do to you as far as impeaching your credibility on the stand as witnesses. He did an overly zealous job of that, I would say. And in the real world, that might not happen, but a few of the questions would have been allowed by the judge at least, and your credibility would have slipped a few notches by the jurors. Remember, you're a witness. You're a police officer. You're still a witness. Your credibility is going to be weighed against all the other witnesses. Yes?
Could the tow truck drivers be considered if the crowd
In
was
the
there?
real world, ladies and gentlemen, let me tell you right now, we're lucky to get the police officer into court. I don't think we kept the tow truck driver or anybody else. And the judges certainly would not want to let that trial go on for 2 or 3 hours in the district court.
If I may,
I just want to say just a couple things. First of all, you got to be real careful with your paperwork. Real careful with your paperwork. I don't know that would find you, but my real defense counsel may or may not do this. Okay. Secondly, when you can understand, if you get confused, you don't know. You've got to say, I don't know. You know, or I don't remember. If you get confused, you need to say, I don't understand. I mean, you can't make a mistake and say, yeah, I lied. Where's the bail? You're going to take your ass away, son, you know? I mean, and remember, when you choose what complaints to be made, you have to run down the elements of the crime that you were talking. That's why the elements are listed there for you. Well, I was going to put Sergeant O'Hare, I forgot Sergeant O'Hare. He was watching out the window. He was going to testify that the gun was in fact in the ground. Okay? Remember, I told you, the cops can't lie. Okay?
Everybody
Everybody
else
else
lies.
defense counsel lies, yeah, and the defendant can lie, but the policeman can't lie. You can't be a policeman and lie on a freaking stand. There's got to be some difference between you and them. Okay?
There's not a case in the world, ladies and gentlemen, really, that is witness law. There is not a single case in the world. I don't care if it's any case, even cases that have received notoriety now in the newspapers. There's not a case in the world that's worth lying on the stand under oath law. Because you'll be charged, you could be charged with perjury, and you'll be disgraced, and maybe even sentenced to jail. So please, tell the truth, and if you don't know, you don't know. Or you don't know. Okay?
Shut that up. Apparently there's some confusion on whether or not you were in fact charged with unlawful carrying. Okay? If you were charged him with unlawfully carrying, if he owns the car, because you can infer from that he parked the car there. Okay? This bullshit that I was doing about, you know, the windows were open, unlocked, rolled down, who the hell is going to go into your car, break into your car, and put a gun in your glove compartment? You know what I mean? It's not, it doesn't make a whole lot of sense. Remember the definition of probable cause. More than mere suspicion, but not necessarily enough to sustain a conviction. Okay? So absolutely you would put him in for unlawfully carrying a dangerous weapon, to wit, a firearm, 269 subparagraph A, wouldn't it? A. I owe you. Okay? Now look at this is the place where you make your mistakes. Okay? Officer, Counselor, Lawyer Walsh, Billy Walsh and I, and the other people here, we have a whole lot of experience in court. I mean, the first time we got up in court, we were shitting our pants just like you will be. You know, you go up there and you say, state your name, and you go, yeah, you know? It's just like, you know, the first time you rode a bike or anything else. Once you get to do it, there's nothing to it. You just think about the question and answer the question that's asked. Were you working? Not, yes, I was assigned to the Bravo 101. Yes.
Listen to the question and then answer.
Yeah. And the other one, when you're fighting in a scuffle, okay, you're in a scuffle, and then the weapon's found on the ground. Okay? Could you infer that he dropped it? Well, goddamn it, you better have. Because any cop with two guns is going to be fighting. You know, my thing as defense counsel here, my only thing is my client is guilty of sin. We all know he's guilty of sin. We saw it, right? My client is guilty. My only ambition is to create a reasonable doubt in one juror. Just a reasonable doubt in one of them. It's going to take 6 of them acting in concert to convict my guy.
Or 12 in a superior court.
Yeah, 12 in a superior court.
You just need one juror who says a reasonable doubt. And that's it, the case is gone.
So
unanimous verdict.
It's a righteous pinch unlawfully carrying for the one in the glove box. It's a righteous pinch unlawfully carrying. That little scuffle that, who was that? B platoon. Who was it? B platoon. You guys saw that. That wasn't A being a PO. You know, a little, you know, you gotta deal with that shit. You know, what do you think? People are gonna let you lock them up? You gotta, I mean, if I punched him, sure. And I really didn't kick you, did I? Did I? Good. Well, if I kicked him, I certainly didn't know it. But I mean, you know, that little bit of hurling, well, that's not assault battery, too. It certainly wasn't disorderly person. Sure. The other thing I just wanted to tell you is, you know, take command of the situation. You're the policeman. I'm walking back and forth, Walshing is around. You already decided I'm under arrest. You take my ass away. You know, don't let me, you're answering my questions. If I'm under arrest, I'm under arrest. You're gonna put me in handcuffs and then you're gonna search me.
I just want to say, charge it. You don't know if it's carrying or possession, please always put them into the carrying. Because if we can't prove carrying, we don't have enough evidence. The judge or the jury can always find them guilty of unlawful possession. They can reduce it from an unlawful carrying to an unlawful possession, which is what's known as the lesser and included offense. But if you're charging with just a possession and it's a carrying, the Commonwealth can always amend down. But in order to amend up, we got to go in the clerk's house and file a new complaint. So if it's close and you're not sure if it's carrying or possession, you're not sure about the possession of the defendant with the gun on his person, charge the carrying, and if we have to reduce it to possession, or the judge or jury reduces it themselves to possession, we still got something there. But go with the carrying if you can.
All right, onward with justice. Let's go.
Okay. Clerk, read the charges.
Next case is Commonwealth versus Matthews. The charges are assault and battery on a police officer, a warrant arrest, unlawful carrying of a firearm, possession of a Class B substance, an accessory before the fact.
Accessory before the fact.
We're count 5 there. Did you see, Mr. Clerk? Somewhere on the sheet.
Don't forget the ever-present disorderly person. This is where they shot the guy dead. They're going to put him in for disorderly. Holy shit.
Before we begin, the Commonwealth would like to make a motion relative to count 4 of the complaint.
Yes, Counsel.
Your Honor, the Commonwealth would like to amend that complaint from accessory before the fact to an assault with intent to murder.
I object, Your Honor. You can't do that.
I'll try.
He knows better than that.
I can't.
He might. The motion he should make to accessory before the fact is like this, Judge.
Okay, we'll call Officer Weston to stand, please.
Officer Weston,
Billy.
Okay, we'll stand to that. I'm sorry.
Billy.
Yeah.
This is Courtney Matthews for this.
Okay.
All right?
All right.
He's dead. Gross.
All right, fine. Okay, we'll call Officer stand.
That's right. For no reason at all.
He's sworn. He's sworn. What time? We're going to go through some of these things. He's sworn. Please seated, officer.
Nice to see you, Warren.
We'll stipulate all the facts. He's a cop. He's working. He was in uniform. He had breakfast.
We'll bring you right to the incident then, officer, okay? Focus your attention right to the
Yes, sir.
February 20, 1990, 10:27 a.m. You were going to, the application be directed to 85 Williams Avenue,
Yes, sir, I did.
okay? And when you got there, what did you see?
Observed a blue station wagon, sir.
Okay, and did you observe anything about the station wagon?
Yes, sir, it was running. There was 2 occupants in the car, sir.
Okay, and did you have any information relative to the 2 occupants?
Yes, sir, they were believed to
I object.
Yes, sir.
Yes, sir.
State of mind, officer, you want. The officer can testify to the state of mind of what he believed the 2 occupants were or would be.
I object, Your Honor. That is a state of mind.
The question, rephrase the question, Counselor.
Okay, did you saw 2 occupants, is that correct?
Yes, sir.
Okay, did you know or have any reason to believe anything relative to the 2 occupants?
Yes, sir.
Okay, what was that, officer?
I object.
I think it would be state of mind.
You think that would be right? Okay.
Answer the question.
Yes, sir, I received information that the suspects...
Not the information, just your belief, officer. Just what you thought. What did you think?
Maybe the suspects were wanted for warrants, sir.
Okay, what kind of warrants, officer?
Assault and battery on a police officer, sir.
Is that all?
I'm not sure, sir. Armed and dangerous as well, sir.
Okay, so what'd you do?
I object, Your Honor. What else warrants? Armed and dangerous? Was it armed and dangerous, that warrant?
The suspects were believed to be armed and dangerous, sir.
Your Honor, that is unresponsive to the question. What else warrants? Okay, what other warrants was there? He responds armed and dangerous.
Answer the question, officer.
You should say, officer, have warrants on them, and we believe them to be armed.
They had warrants on them and we believed them to be armed and dangerous, sir.
We do not object to that.
What happened then, officer? What'd you do as a result of that?
I made several attempts to make contact with the 2 occupants by use of the siren, the cruiser horn, and as well as the lights were on as well, sir.
What happened when you made those attempts, officer?
They ignored the attempts, sir.
Okay, so what'd you do as a result of that?
We called for backup, and we waited for backup to arrive. Myself and Officer Westhaver approached the vehicle.
Okay, what side did you approach?
The driver's side, sir.
Okay, what happened when you approached the vehicle, officer?
I knocked on the window, tried to make contact. Took several times to make contact with the driver of the vehicle, sir.
When you say several, can you be more specific, please?
Approximately 4 times, sir.
And how were you trying to make contact?
By knocking on the window, sir.
Were you saying anything?
Yes, sir.
What were you saying?
I was asking him to roll down the window, sir. Turn down the music.
Better respond.
After I asked him twice, sir.
Twice.
Yes,
Okay.
sir.
What did he say?
He said, he asked me what I wanted.
All right. What happened then?
I asked him for his license and registration.
Did he produce it?
No, sir.
Did he say anything?
Yes, sir.
What did he say?
He made several statements relative to the fact of why I was stopped.
Several statements. You have to be specific. How many statements did you make? Remember, if you remember.
I'm not quite sure to the exact statement, the exact words, sir.
What was the effect of the statements?
He believed that it was racially motivated, sir.
I'm sorry?
He believed that it was racially motivated, sir.
Well, what did he say? Remember? Be specific if you can't be.
He said, why are you white cops pulling me over?
Okay, and what did you say to that?
I asked him again for his license and registration.
What happened then?
He refused to do so.
Okay, what did you do?
At the third time, I asked him to step out of the vehicle, sir.
Did the defendant step out of the vehicle?
Not the first time, sir.
Okay, you asked him again.
Yes, sir.
Did he step out then?
At that time, he then stepped out of the motor vehicle, sir.
All right, now what happened, did you notice anything unusual about the defendant when he stepped out of the vehicle?
Yes, sir. He was very abusive.
Yeah, you say abusive.
Object, Your Honor. I couldn't hear that response.
Abusive.
Oh, thank you.
That's subjective, officer. Could you tell us what he did?
He got in the car, he was making motions such as this, being very loud.
Okay, what was he saying, if anything?
Why, this is racial, what do you think this is? Charles Stewart all over again. I then asked him to place his hands to the side.
Okay, did he do so?
The first time he refused to do so. The second time he pulled a submachine gun, a 9mm Uzi out of his back, and fired 3 rounds.
How far were you from the defendant when he pulled the gun out, officer?
Approximately 10 feet, sir.
10 feet. And how many rounds did he fire?
3 rounds, sir.
And what did you do then?
I went to the ground and set my 2 bullets, sir.
Okay. What happened after that, officer?
That's my recollection. The other officers took control of the situation, sir.
How did they do that?
I'm not quite sure, sir. I was injured.
Okay. What happened after that? After control, as you say, was taken, if you know?
One of the second suspect that was in the car fled on foot.
Hey, Object, Your Honor. When he was injured, he was in the ambulance, wasn't he?
If you know, I said. Are you aware of anything else?
Yes, sir. I saw the second occupant fled.
You know where he fled, what direction?
He fled down the Williams Ave.
You know, did anybody assume?
2 officers, Officers Morrison and Scannell.
Do you know which officer returned the fire from the defendant?
Officers West Taylor and Scannell.
Okay. Thank you. No further questions.
Officer, you say that you came upon and attempted to contact. Is that what you said?
Yes, sir.
You attempted to contact a car that was stopped. Is that true?
The car was running, sir.
Was it stopped?
Yes, sir.
It was stopped.
Yes, sir.
And you, lights and sirens and all, what did you expect them to do when you signaled lights and sirens and stuff?
To acknowledge the fact that I was trying
Well, what did you want to wave to them or what?
No, sir. I wanted to talk.
Well, officer, in the course of your patrol, when you turn on your blue lights and stuff, people pull over and stop, do they not?
Yes, sir.
These people were already pulled over and stopped, right?
Yes, sir.
You stated there were warrants on you.
Yes, sir.
And when you walked up to the car, what was my client, the deceased person's name?
William Gross, sir.
You knew that?
I believe.
Did you know that? Yes or no? You didn't know who it was.
No, sir.
So you didn't know there was a warrant on you.
No, sir. I was not quite sure he was the person, sir.
So what you saw was 2 black males, parked, reasonable gentlemen, bothering no one, and you went up to them? You just said you didn't know there was a warrant. Is that true?
There was a warrant.
Didn't you just say you didn't know there was a warrant? Yes or no?
Yes, sir.
So what made you bother my client
mercy.
What? I'm sorry?
So we approached the vehicle.
Why? Why did you approach this vehicle, officer? Don't you remember why you approached it? Stand black. That's all right, sir.
Mr. Matthews, another outburst like that, I'm going to have to...
You ran my life and racially injured again.
We have not proven that.
It goes on and on, day after day. 200 years. Racist cops. This kid, look at this kid.
First warning, all right, one more time, out of the court.
I'm sorry, Who's going to put me out, him? This is the kind of shit you're gonna hear. Why did you approach my client and his friend?
Received information, sir.
From whom? Did you receive it? Was that the scenario you received information?
Yes, sir.
What information did you receive, officer?
There was two suspects that were believed to have warrants beyond the dangerous.
Okay, so you approached my clients for what purpose?
Make an identification, sir. To find out if they were in fact the we had received information on, sir.
Are they required to identify themselves, by the way?
Excuse me, sir?
Are they required to identify themselves?
Yes, sir.
Next time you mark your head like that, son, I'm gonna tear it off and give it to him, he's gonna put it in the dock, all right? Well, the operator is required to identify himself, is that true?
Yes, sir.
How about the other guy? Is he required to identify himself, do you think?
I was not speaking to him, sir.
Regardless, you said you approached him to identify him.
Yes, sir.
He's required to identify himself?
I believe so, sir.
You believe so? You know, yes or no?
No, sir.
You don't. So you're doing a threshold inquiry, is that what you're doing?
Yes, sir.
Did my client refuse, excuse me, did my deceased client refuse to give you a license registration?
Yes, sir.
By the way, was there a fact that a warrant relative to this man?
Yes, sir.
What's this man's name?
I'm not quite sure, sir. It's Matthew Courtney Matthew.
You testified he fled, is that true?
Yes, sir.
Let me ask you a hypothetical situation, officer.
Yes, sir.
Do you understand what hypothetical means?
Yes, sir.
What's it mean?
It's make-believe situations, sir.
What's it mean?
Make-believe situations.
Excellent. Good. Okay. If you were sitting with one of your buddies, and two black officers come over for no apparent reason, and you get out of the car like my client did, accosted by another officer, and the next thing you know, his body's shot down like a dog, would you run?
Objection. Former question calls for speculation on the part of the witness.
Sustained.
Go further.
We'll call Officer Morrissey now. Be seated, officer. Thank you. Morrissey.
Ross, I'm going to direct your attention to 20th of February at about 10:27 p.m. Were you directed to our 85 Williams Avenue?
Yes, sir, it was.
What was the purpose for being here?
It's a backup unit, sir.
To who?
To the E101 unit, sir.
Okay.
Who stipulated all that?
Right. When you got there, officer, what did you see?
I saw the two officers starting to approach the vehicle, sir.
Okay. And what happened when they were approaching the vehicle?
The officers approached the vehicle, sir. My partner and I took positions of cover to cover those officers, sir.
Okay. What happened then, after that?
Officer Stanton attempted to make contact with the driver. He refused to do so several times.
Did you hear Officer Stanton make those requests?
Yes, I did.
Okay. What happened after we made those requests?
After making those requests several more times, the subject finally exited the vehicle.
Okay. And what happened then?
Officer Stanton was asking for identification.
Was any produced?
No, sir, there wasn't.
Okay. What happened after that, sir?
The subject started getting evasive towards questioning, sir.
You remember what the subject said?
Not exactly, no, sir.
Okay. What happened after you wouldn't answer the questions?
A short scuffle assumed, sir, and then I heard a couple of rounds being fired, sir.
Okay, now, who was involved in the scuffle?
The scuffle was with Officer Stanton and the subject, sir.
Okay, and what did you do as a result of the scuffle?
I heard a couple of rounds being fired, sir, and I directed my attention towards that area, sir.
Okay, and what did you do?
I pointed my weapon towards the individual, sir.
And then what happened?
A couple of more rounds were fired from the other officers, sir. The subject fell to the ground along with Officer Stanton.
Okay, what happened then?
Officer Webster, who was on the passenger side of the vehicle, attempted to get the other subject out of the vehicle.
All right, and did the other gentleman on the passenger side come out?
Yes, sir, he did.
And what happened when he came out of the vehicle?
When he got out of the vehicle, sir, he pushed the door and ran towards Washington Street, sir.
He pushed the door, you say?
When he was opening the door, as he was opening in a single motion, he continued to flee.
And he fled?
Yes, sir.
On foot? Where? Down where?
He fled towards Washington Street, sir, and took a right.
Okay, so what happened after that?
I started to follow the subject along with Officer Scannell, sir. We followed him for approximately a block where we stopped and detained the suspect.
Did you follow him in your motor vehicle?
No, sir, on foot.
Okay. Did you end up catching up to him?
Yes, sir.
How far away were you?
About a block and a half.
Okay, what happened when you caught up with him?
We placed the subject under arrest.
For what, sir?
He was fleeing and involved in that commission of that crime, sir, and over the radio before we arrived, we had heard the speculation of warrants and the fact that they were suspected to be armed, sir.
So you placed him under arrest?
Yes, sir.
Okay, when you placed him under arrest, what did you do?
I brought him back to the original scene, sir.
Okay, and what happened when you brought him back to the original scene?
Conducted a search, sir.
What kind of a search, officer?
I conducted a search incident to arrest, sir.
All right, and did that search incident to arrest reveal anything?
Yes, sir, it did.
What did it reveal?
It revealed a weapon and a white powdery substance, sir.
What kind of a weapon did it reveal?
A .22 caliber revolver, sir.
Do you have that revolver with you, or is that all stipulated with the drugs? What else did it reveal?
It revealed a bag full of white powdery substance, sir.
Okay, you brought that with you?
Yes, sir.
Is that analyzed?
Yes, sir.
Result of that analysis?
The analysis was that it was 4 ounces of cocaine, sir.
Okay. What happened then, officer?
The wagon was called, the ambulance had arrived. Officer Scannell and myself conducted an inventory search on the vehicle, sir.
Did the inventory search reveal anything, officer?
No, sir, it didn't.
Okay. Do you see the person you arrested on that evening in question? Here, President Klitz there.
Yes, sir, I do.
Please point him out, identify for the record. Your Honor, may the record please reflect identification of the defendant by the officer. May it reflect that?
Yes, yes.
Thank you. So
Police Officer Murray. Morrissey, isn't it?
Yes, sir.
Say again why you placed my client under arrest.
I placed the client under arrest after he fled from the vehicle, sir, where an officer was just shot.
What crime does that constitute, son?
Assault with intent to commit murder, sir.
On my client?
Yes, sir.
My client committed an assault with intent to commit murder?
He was the principal of that, sir.
How was he a principal of that?
During the commission of the stop, sir, he was with the individual.
He was with him. In any way, did he aid, abet, or encourage him to do that?
To the best of my knowledge, from what I can see, I don't know, sir.
You don't know. You have no probable cause whatsoever to place my client under arrest at that point for anything whatsoever, other than the fact he ran when he saw his friend shot. Isn't that true?
No, sir.
It's not true. When do you need probable cause to arrest, officer? When do you need probable cause to arrest?
Before making the arrest, sir.
Or at least at the moment of arrest, would you agree?
Yes, sir.
Tell me again what crime you're charging him with.
Sir, the subject was charged with several crimes, sir.
What crime did you charge him with at the moment you placed him under arrest, officer?
Assault with the intent to commit murder, sir.
You know that's bogus, don't you?
No, sir.
When the man with whom he was seated got out, got in a scuffle with a police officer, and ultimately shot this officer, you're going to put my client under arrest for the actions of the other man because he was simply seated in the car?
Yes, sir.
Were you taught that in the academy?
Sir, I was taught that as a principal, he could be charged with that.
But what constitutes his being a principal officer?
The fact that he was there and it's no one wanted to...
Just being there is insufficient. In law.
Objection, Your Honor. That's a question for the jury.
It's not a question for the jury. Questions of law are for you, Your Honor.
You heard my objection?
Yeah. Objection sustained.
I would like to be heard on that, Your Honor.
Thank you, Counselor.
I mean, if we're gonna have a moot trial, let's do it right. I mean, this officer testified that he placed this man under arrest for being a principal for assault, I presume while armed, with intent to rob or murder. Okay? His testimony is he was seated in the car. And then after his friend was shot, he ran away, and he placed him under arrest at that point. Perhaps you want to take that under advisement.
We heard that, thank you.
Where did you get the drugs?
Sir, out of the individual's coat pocket, sir.
Which coat pocket?
The one that he was wearing, sir, black.
Which coat pocket, son? I presume it was the coat that he was wearing.
The coat that contains the hood, sir.
Where exactly were the drugs on the coat that contains the hood?
In the compartment that contains the hood, sir.
Where is that?
On the top part of his jacket, sir.
Can you be a little more precise? How did you find the drug?
Through the search, sir.
Okay, exactly. What did you do?
As I was searching him, sir, I felt the area around where the hood is contained, and I felt a substance that would not lead me to believe that it was a hood, sir.
Okay, and then what?
I opened that container and I pulled it out, sir.
Okay. How about the gun?
Sir, I found a gun in the crotch area of the subject, sir.
You found it personally?
Yes, sir.
Is my client licensed to carry a firearm?
No, sir, he is not.
Did you ask him if he was licensed?
Not at that specific time, sir.
Did you hear any other officer ask him if he was licensed?
Sir, you know.
I'd be a little embarrassed if I showed you a license to carry, wouldn't you?
Yes, sir, I would.
Yeah, you would. Look something like this.
Yes, sir.
No further questions.
No further questions, Your Honor. That will be the Commonwealth's case.
Okay. Yes, sir.
Well, you know, in closing, Your Honor, I think, again, we're going to need a director for you were winning up until the point where you placed him under arrest for something for which he had no... I mean, there's a complaint made against this man. This is obvious, a ridiculous prosecution of my client. Okay? It's a situation, Your Honor, accessory before the fact. There's been no testimony to that. The warrant, well, we'll get the warrant. Unlawfully carrying a firearm. He doesn't testify. No one asked my client whether or not he has a license to carry. Possession of Class B substance. That would all be good if the arrest is good, Your Honor. But I understand that the arrest at this point in time, I would argue, certainly, that he had no probable cause to arrest my client for anything to that point. It was certainly not for what he said. Hence, the gun, even if it were unlawful for him to carry, and the drugs, even if it were unlawful for him to have, are simply fish that he cannot keep. It's fruit of a poison tree. If the arrest is thrown out, I make a motion that all the evidence be thrown out. I respectfully suggest that the Commonwealth does not carry the burden to any degree to make this a righteous arrest. And hence, the arrest no good, the search and seizure, all but enough.
We'll address count 2 and 3. Relative to count 2, unlawfully carrying a firearm. Commonwealth has met its duty here to overcome the directed verdict and beyond reasonable doubt. The defendant possessed a firearm on a public way, and there was movement in his flight from the officers. My worthy brother had an opportunity during the course of his cross-examination to inquire about a license to carry a firearm. He did not make that inquiry, nor was no license produced, and hence the charge of count B, unlawfully carrying a firearm. Relative to count 3, Your Honor, possession of a Class B substance. We must ask ourselves this morning, did these police officers have at least reasonable suspicion, if not probable cause, it's Big Brother, to go down and to chase the suspect as he fled from the scene where shots were fired and violence had been used? Did the officers at least have reasonable suspicion to pursue that man and to conduct a pat-down frisk for weapons under Terry versus Ohio when a person is running away from a scene where a police officer has just been shot. Your Honor, I will submit to you and to the ladies and gentlemen of the jury, the defendant's flight was evidence of his consciousness of guilt, and that gave the police more than reasonable suspicion to stop him and more than reasonable suspicion to conduct a threshold inquiry, pat-down frisk for weapons, which were in fact found on the defendant, and in addition to that, Your Honor, a large bag of Class B substance, cocaine, was found on the defendant relative to that stop, frisk, and later, which became a search incident to arrest. The Commonwealth has met its burden on count 2 and 3, and I would ask the ladies and gentlemen of the jury to find the defendant guilty of count 2. Thank you.
Thank you, Your Honor.
Yes, Counsel.
Your Honor, if that were the facts as testified to by the police officers, we'd be dead. Okay? If this officer got up and said, when he ran, he stopped him to do the threshold inquiry, and as a result of that, patted him down, came up with a weapon, placed him under arrest, down found the drug, we would have no case, Your Honor. And we would have no case. This officer testified that he placed my client under arrest on some bogus, worthy counsel for the prosecution, Mr. Assistant District Attorney Walsh, makes an outstanding case, perfectly legally correct, but those are not the facts of record. And I suggest, Your Honor, as a matter of law, that I respectfully request that you rule and not bring it to the findings of fact.
Okay, on the accessory before the fact that has been dismissed, ladies and gentlemen of the jury, you are to, based on the evidence that's brought forth in this courtroom today, I'm asking you to make a decision on counts 2 and 3, and you have 30 seconds to do so.
Excuse me, Your Honor, before you're going to give this to the court?
Yes,
I mean,
Counselor.
to the jury? He arrested him for assault while armed with intent to rob a murder. This is an outrageous, egregious miscarriage, Your Honor.
I'm sorry.
I respectfully request one more sentence, Judge. He says he arrested him. No, you said he arrested him, charged him with assault while armed with intent to murder, and doesn't make any such complaint.
We have brought forth here.
There is no.
That there's an outstanding warrant talking about a police officer. The suspect as described, and this is not for probable cause. In this particular case, you're to rule on counts 2 and 3. That is the decision of the court. Now, remain seated and quiet, Counselor.
Yes, Your Honor.
Thank you.
No matter what we do, we appeal to a real judge. That's right, you can be rich. I'm sure you were taught at the time of arrest. You have probable cause to arrest for a specific crime. Not, I know we did something. They have absolutely every right in the world to do the threshold inquiry and the pat down for weapons. You got a cop shot and you got a prisoner dead. You with me, Parham? You with me, kid? Just barely. You can't afford to miss anything either. What he said under oath was fatal. He placed him under arrest. I mean, you know, that was a bullshit. You can't charge him. He was taught different than that. He's not a principal just by being there, nor is he an accessory. Okay, you gotta have a righteous arrest in the beginning, at the time of arrest. Go ahead.
Yeah, the officer's testimony is going to could potentially make a great case of not guilty. Did you officer? enough reasonable suspicion to chase the guy, stop him, and do a threshold inquiry and come down to it? Most certainly. But you gotta be careful of the wording you use. Reasonable suspicion is threshold inquiry. Okay? Reasonable suspicion is the little brother of probable cause when you think about it, right? And a threshold inquiry is the little brother of an arrest. When it grows up, it becomes an arrest. So the little threshold inquiry became an arrest. But you gotta be careful with the phrases and the terminology you use because it's critical. It's critical. Now, if this officer said, I faced her, conducted the threshold inquiry, then placed him under arrest, no problem. But a potentially fatal error there regarding the testimony of the officer, which I tried to make up a little bit by glossing over in my closing argument. Yes?
Sorry, was that possession of cocaine?
Yes. I'll tell you about possession. It's a subjective thing with the judges. Packaging plus amount. Okay, now packaging for possession with intent is usually multiple packages. I say 3 or more usually from what I've seen. All right? I had a guy last week, 3/4 of a pound of marijuana. You can't tell me that's personal use. All right? The judge found him on possession. We charged him with possession with intent. The judge reduced it and charged him on straight possession because it was packaged as one big bag.
Was it 14 grams warrant trafficking? 14 grams in trafficking?
I would say so, but it might be reduced down to straight possession because it was packaged as one. That's what I'm trying to say. I had a judge once in the BMC, just real quick, 50 joints. 50 joints my partner and I had on this guy. And we charged him with possession with intent. And the judge is still up there. Takes off his glasses and he says, "Officer, you charged that man with possession with intent for 50 joints?" And we're calling marijuana cigarettes, trying to be, proper. He says, "You charged that man with possession with intent for 50 joints?" We said, "Yes, indeed." Right? He said, "That's personal use," he said. You're personal use now.
Okay, the people who arrested Officer Culhane, Evelyn, we put Officers Evelyn and Gaffney.
Do we get a ruling on this one?
Yes, we're waiting for this.
You people get ready.
Look ready. Everyone remain patient, seated. It's going to be relatively short one, people. If defense counsel...
Do one more before lunch.
Okay, is the jury short decision?
Yeah, sure.
Your Honor,
Quiet in the court, please.
Your Honor, we find the defendant guilty on both charges.
Thank you.
Let's go from the 1-1. We'll just call the officers up. Gaffney and Evelyn, right? Isn't this one? Is you two guys? Okay. Who should I call? Gaffney? Okay. Put Gaffney on the stand. Believe it or not, in the real world, it's about as much prep time as you're going to get. 5 minutes with the DA before, in the morning of the trial or before you go into the courtroom. It's called all the luxury of preparation the government has. Mind you, the defendant has been conferring with his attorney probably since the day he was arrested. So they've got a lot more preparation than we do.
Quiet in the court, please. You want to read the charges? Clerk? Clerk, please read the charges to the court.
Next case is Commonwealth versus Jeanette Sweetheart. The charges: carrying of unlawful weapons, possession of Class B substance, possession of Class D substance, refusal to submit to a police officer.
Good morning, officer. I'm going to direct your attention to February 22nd, 1990, approximately 11:05 a.m. Did you have occasion to be in the vicinity of 85 Williams Avenue, Hyde Park? Would you please tell the court what you saw when you got there at that time?
There was a dark blue station wagon LTV parked in the rear of 85 Williams Avenue, 2 suspects in the car.
Okay. And had you had some information regarding that motor vehicle, officer? Yes or no?
Yes.
As a result of that information and seeing the car there, what did you do?
We went up to investigate, find out if they were okay and what was going on.
You speak nice and loud, please.
We went up to find out what was going on.
What was going on, okay? So what did you do?
We approached the car. My partner approached from the driver's side.
Your Honor, I'll object. I can't hear it.
You gotta speak nice and loud. Please don't be bad.
Very loud. Don't be shy.
I approached the car first. My partner approached from the driver's side of the car. When I approached the car, I witnessed the defendant and a gentleman in the car with her passing a joint, what appeared to be a joint back and forth twice.
Okay, what did you do as a result of those observations, officer?
My partner went up to the driver's side.
I object. What did you do?
You do, listen to my question.
Just you, officer.
I watched where the joint fell and just kept an eye on it until my partner.
I can't hear her.
Speak up, please, officer.
Speak up, please. You know, those microphones in the courts don't magnify your voice. They only record. So even that microphone in the court's not going to help you. You got to speak nice and loud.
I just watched where the joint would appear to be a joint where it landed and waited till my partner approached.
Okay? And where did your partner go to?
He approached up to the driver's side.
All right? And what happened then, officer?
He requested the license and registration 3 times, and it was not given to him.
And that was your partner?
Yes, sir.
Who was Officer
Evan.
Evan? Okay. And what happened then? Did you, well, first of all, did you, I'll just withdraw that question. Did you hear your partner make those requests?
Yes, I did.
Okay. Was anything forthcoming?
Nothing was given to him.
Okay. What happened then, officer?
I then informed my partner that the joint was thrown out the window.
Okay. Did you see the joint get thrown out the window?
Yes, I did.
Who threw the joint out the window? Okay. What happened then, officer?
He then asked, my partner then asked the driver to step out of the car.
Driver to step out of the car. Okay, yes, yeah.
I'm not sure how many times he asked him to step out or step out.
All right. Did the driver step out of the car?
He did.
Okay. What happened then?
My partner informed him that he was under arrest and that he needed a search, cuffing and search.
I can't hear her, Judge. Can you hear her? You're sitting beside her. You can't hear her.
You got to speak loud enough for the jury.
Can you hear her, Jerry?
No, sir.
Everybody listen up now. All right?
You're talking to bad guys like that out on the street, you're not going to get too much respect. Nice and loud and forceful.
Command voice.
Command presence.
Can you repeat the question, please?
Yes, all right. You said if you saw a joint thrown out of the window, what happened then?
My partner requested that he step out of the car, informed him that he was being placed under arrest. He cuffed and searched the male suspect.
What was it? Yeah. Right. Relative to the female, what did you do?
I asked her to put down the window. She did not put down the window. She proceeded to jump over to the driver's side of the car. She went down on the floor, grabbed the keys, started the engine, and put the car in drive.
Okay, what happened then, officer? What happened?
We requested backup. Backup showed up. Officer Bowman informed her to shut the car off and step out of the car. He informed her 3 times and she did not step out of the car or shut the car off.
Okay, what happened after that?
I went over to the driver's side of the car. I reached in, put the car in the park, and shut the car off.
Okay. What happened after you shut it off, officer?
We asked her to step out of the car again. She stepped out of the car at this point.
Okay, what did you do when she stepped out of the car?
I told her to raise her arms and I started to proceed to cuff her.
Okay. Do anything else?
When we were cuffing her, when I was cuffing her, a struggle ensued.
All right. What happened in the course of that struggle, if anything?
Officer Bowman and I restrained her and cuffed her, and then I searched her.
Okay. Did you search?
Yes, sir.
Reveal anything to you, officer?
No, sir.
Okay. What did you do after you searched the defendant?
After I searched the defendant, we took her back and put her in the car.
Okay. Was anything else searched?
The car was searched, sir.
Yeah, I couldn't hear that response.
Car was searched. Did you search the car?
No, sir.
Who searched the car?
Officer Bruno, Officer Bowman.
Okay. Okay. There was nothing else found on the defendant then, is that correct, during the course of your
No,
search?
sir. No, sir.
All right. Now, who transported the female defendant back to the station?
Officers Assad, Officer Gallarelli.
Okay, were you present at the booking desk?
Yes, I was, sir.
Okay, what happened at the booking desk, ma'am?
At the booking desk, I searched her again and found 2 dirk knives and 4 ounces would appear to be white substance.
And that was during the course of the booking?
Booking search, sir.
All right, and what did you do with that property, officer?
We sent it to be analyzed.
Okay, you have the analysis, we stipulated all of that. you as Jeanette Sweetheart, be placed under arrest here, President Courtney.
Yes, I do, sir.
Please point right and identify her for the record. For the record, sir. When you identify someone, now point them and identify the woman seated at the counter table wearing a red dress.
The woman seated at the counter, sir, wearing a red dress.
All right? Thank you, officer. No further questions at this time. The witness counsel.
Okay, you walked over to my client and what did you say to her?
I told her to open the window, sir,
Why was that?
because they were not opening, they were not giving the registration or the license.
Well, was it incumbent upon her to give the license registration?
No, sir.
So she had nothing to do with it, is that true? So what are you bothering her for?
In case she was going for a weapon, they would give me.
Did you see her make any moves towards the weapon?
She did go down on the floor, sir. She did not pull out a weapon.
Had you already told her to get out at that point?
Yes, sir. I just asked her to roll down the window.
Had you already told her to roll down the window?
Excuse me, sir?
Before she went down to the floor, did you tell her to roll down the window?
Yes, I did, sir.
Why?
So in case I had to do anything to restrain her from getting a weapon, sir.
Did you hear that?
No, Your Honor.
Would you ask her to speak up, please?
Could you speak up, please?
When you testify like that, you sound like you don't even believe your own story. How do you expect them to believe it?
Speak right up. It's very embarrassing the first time you do it, yeah. First time you do it to everybody. I feel really bad. Do the best you can.
I requested that she roll down the window when she was seated in the observer's part of the car.
Okay. Are you charged here with refusing to submit to a police officer? Is that true?
Yes, sir.
Did you issue her a citation?
Yes, sir.
Where is it? Did you write out a citation?
Yes, sir.
No, did you?
No, we weren't issued those to rights, sir.
Okay. Unlawful carrying weapons, possession of Class B substance, Class D substance. Is that true?
Yes, sir.
Now you say you took my client and you placed her in handcuffs, you and someone else, right?
Yes, sir.
And then you searched her. Is that true?
Yes, sir.
You didn't find anything.
No, sir.
Right. And then all of a sudden at the booking desk, out of the view of all the good citizens, 2 dirk knives and some cocaine appears. Is that true?
Yes, sir.
Just appeared. Well, did you search her, yes or no, before you put her in the car?
Yes, sir. I did not do a thorough search.
You did not do a thorough search. You put a person allegedly carrying 2 dirk knives and cocaine into another policeman's cruiser?
Yes, sir.
Well, you can find that message there. Did you look in that rear seat before you put her in there?
No, sir.
Could those dirk knives get in there when she got in the back seat? Yes or no? Could they have been
Yes,
there?
sir. I didn't place her in the car.
Didn't you testify you placed her in the car with Gallo
When I took
Elliott?
her back to the car, I did not say that I placed her in the car.
Did someone place her in the car?
Yes, sir.
Okay. Did you see anybody search the rear seat of the car before you put my client?
To the best of my knowledge, no, sir.
Okay, but you do know you searched it,
Yes, sir.
and you didn't come up with anything.
No, sir. I
And
did
you,
a field search.
excuse me,
I did a field search.
what's a field search? Is it possible to jerk back the cocaine on the back seat of that cruiser? Yes or no?
Objection, Your Honor. He asked the question, what's a field search? He didn't give the officer a chance to answer.
The reason I did because there's no answer to that question, Your Honor.
Objection sustained.
Okay, answer. Tell me what a field search is.
Field search is a limited search, sir.
Limited search?
Yes, sir.
Where were you taught that, officer?
At the academy.
In fact, you were never taught any such thing. Is that true?
No, sir.
Be truthful now. You were never taught any such thing. consider the shakiness of that testimony, I really have very, very little to say, except the credibility of the officer. The officer just isn't to be believed. I mean, it's outrageous to say I did a field search and then come up with this make-believe story about a field search. I mean, people on the street know there's no such thing. I mean, here's an officer who states under oath she only did a field search so that she put supposedly my client with 2 jerk knives and cocaine in the back. You know she didn't put in her own proof. No, she got those other 2 bananas to take. Supposedly an armed subject. Outrageous.
Your Honor, we confine our arguments to complaints and to the evidence you're going to relative to it. Relative to count 1, carrying unlawful weapons. The officer testified that 2 jerk knives were found on the defendant at the booking desk, where a more thorough search was conducted of the defendant. We believe we've met the element of carrying a dangerous weapon on the defendant. Relative to count 1, the defendant should then be found guilty as charged. Relative to count 2, the possession of Class B substance. The officer testified in the course of the search at the booking desk, Class B substance was revealed was taken from the defendant's driveway area. Defendant in the Commonwealth, the defendant should be found guilty of count 2, possession of Class B substance. We have met our verdict relative to that count. Relative to count 3, possession of Class B substance, the officer said she approached the vehicle. She saw the defendant smoking what she believed to be a joint, and it was discarded off the window of the officer examined it, turned out to be remnants of a marijuana cigarette. Class B substance, Commonwealth has met its verdict relative to count 3. Relative to count 4, refusal to submit to a police officer. The officer testified that she made numerous requests, her and other officers, to Miss Sweetheart. When Miss Sweetheart commandeered the motor vehicle and tried to drive away, and Miss Sweetheart refused those requests initially. And relative to count 4, the defendant should be found guilty as charged refusing to submit to a police officer. The officer testified that she conducted a preliminary search of the defendant in the field, and then a more thorough search was conducted at the booking desk. And that is where the evidence on count 1 and count 2 was ascertained. The defendant should be found guilty on all 4 counts. Thank you.
You heard the evidence, jury.
While they're delivering, just a reminder tomorrow morning at 9 o'clock, criminal law remedial at the Jews. How many people coming? Okay? Judge, I found this on the district attorney's desk. It says for the jury. It has a $sign on it.